Southampton Board of Appeals public hearing Thursday, October 27th, 2022. I'll make a motion to open the meeting. Can I have a second?
Second. And
all in favor?
Aye.
Aye.
So first we have two pending decisions, cases 3133 and 3134, 10 Squabble Lane and 12 Squabble Lane. And we have a wetlands permit drafted by our environmental consultant, Chip Voorhees. So I'll make a motion to accept the wetlands permit as drafted. Can I have a second?
Second that.
And all in favor of accepting the wetlands permit as drafted for cases 3133 and 3134, 10 Squabble Lane and 12 Squabble Lane, say aye.
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 So that's unanimous. And then we have case number 3142, 161 Corrigan LLC. The applicant has requested to reopen the case, so they are going to re-advertise and renotice and will be heard at the next available opportunity. So we are...
I would just ask then if there's a motion to approve their request to reopen, please.
So I'll make a motion to approve the request to reopen case number 3142, 161 Corrigan LLC. Can I have a second?
Second that.
And all in favor of approving the applicant's request to reopen case number 3142, say aye.
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 Is the condition that they reposted, re-mail for reopening?
Yes.
Okay, aye.
And Julia?
Aye.
So that's unanimous, and we move on to case number 3132, 370 Great Plains Lane. Is the applicant here?
Good evening, Melissa Dedovich, Peconic Environmental Associates. I'm here on behalf of Lee Kruder, the applicant. I'm also here with Melissa Rivas, who's a partner at Ed Hollander Landscape Design, and Edward Siegel, who is the architect of record. We were just here 2 weeks ago and had some directives from the board, so I'm going to just jump to the chase and go over what we've done. Per the board's directive, we've widened the width of the proposed wetland buffer area adjacent to the man-made dredged pond to 50 feet. So that will be established as a non-disturbance, non-fertilization buffer, utilizing native plantings per the updated buffer planting plan prepared by Ed Hollander's office. We've also, as you recall in the past, provided a timing and methodology from Hollander's office as well as a tree report from Bartlett. Together, this area with the restoration of the 50-foot wide natural landscape buffer will total in a 47% of the property being established as natural habitat. And that's up from the 44.5% that was originally proposed at the last submission. As part of this, and Melissa, if you could show where we've actually relocated the fence line from the corner of the porch to the 50-foot buffer to actually closer to where the pool area is. I met with Tin, the chief building inspector, and he had no problem. We have about 5 feet. It's 55 feet, as you know, from the wetlands line to the house and 5 feet to the wetlands buffer, so that's enough room to get around. And the last thing, we were asked to look at the the motor court that was in the front. We've actually reduced that from 45 feet by 55 feet to 40 by 40, and we've changed it to grass pavers. We've also added 2 5-by-5 planting beds there. And we've added additional evergreen screening between the now proposed temporary parking, or like, as you can see, you can just turn around quickly there. And we've also provided a cross-section that Ms. Rivas is going to talk about now.
So we put together an additional cross-section just to show the relationship of the proposed building to the property line and the public street. So as you can see here, we have 61 feet 6 from the property line to the front of the building. And this gives a little bit of a better understanding of the planting that we're doing between the property line and the house. So we're showing an 8 to 10 foot tall evergreen hedge. This is a holly hedge that's actually on Captain's Neck, so we're using that as our precedent. And then we have some additional shrubbery in front of that, and then we go into that cobble and grass paving that Melissa mentioned. These are also two examples of the same paving within the village. So on the right, this is on South Main, and the one in the middle is on Ox Pasture. And then you can see between that, we've got about a 10-foot walk from the parking or the gas drop-off area to the front of the building. So hopefully this shows a little bit more about the scale of the space and shows where that parking would happen within that front area. Is there anything more?
So one of the things we'd like to do is just go through briefly the other plans, the compliance, zoning compliance plan. And now, as you can see, there's a whole swath of 50-foot all the way up to Great Plains Road. The structures have not changed. There is an updated chart in your package, but it just updates the buffer setback. The next plan should be the overall planting plan, which includes the screening throughout the entire property. The next plan is more detail about the actual native planting plan for the 50-foot buffer. And the next screen is the restoration of the 50-foot wide natural landscaped area. And I believe that's it. So we're here for any questions.
Do you want to address the pergola?
Okay,
By
the
the board.
pergola. Can we have the survey? Okay, this is an open-air pergola. We actually are set back, let me just double check, because we haven't talked about that in a while. The location of the pergola is actually as far from the wetlands as possible. It's gravel impervious underneath, and it's actually set at 13.5 feet from the property line, but then you also have the 20-foot wide flagpole next door. So in essence, it actually exceeds the 30-foot required side yard setback. So again, it's not enclosed, it's open to the sky. It's really just for a little bit of shade over there.
Whose flagpole, who owns the flagpole? Not,
It was the gentleman, actually it was the gentleman who came in and was talking about, he thought we were taking his trees down, and then when we had the property line staked, it turned out they were our trees. So we actually had the entire property line staked. We've actually agreed to bring, and I don't know if you remember this from last meeting, we had a whole fence analysis that we can bring up again too. We're actually putting our new pool fencing inside of the old fencing. All that screening, that existing vegetation, which, do you have that available?
but could you just answer my one question? So you said if you add the flagpole 20 feet and the 13 feet, is that what you said?
It's 13.5 feet plus the 20 feet,
Whose 20 feet are we talking about?
the 20-foot flagpole right there.
And whose property is that?
It is, can you scroll down? I
The other
can't.
person's.
I can't.
Mr. Lawrence, I believe?
No, Christopher Lawrence lives the next property over.
Oh, okay, I don't know what his name is.
Okay.
So why are you counting that as your setback?
Because really the purpose, and we've actually gotten a variance like this over on South Main Street, is in effect, it's doing the same as if it was a 30-foot. Nobody's ever going to be enjoying themselves on the road, on the driveway. So, and again, it's an open-air pergola. It's, the plans have been provided, and there's substantial screening between the property line and where the driveway is. So that's how we were looking at it.
That's
Well,
what
I'm just trying-
that's what we wanted you to highlight or enlarge. Could you show us the screening so somebody's coming down that driveway?
This was submitted in your package in the
Mhm.
last one. I don't know.
How to do it?
Well, we had it for the last meeting.
Mhm.
It should be in your package.
No, I've seen it. Yeah, I
Okay.
just wanted to.
So there's heavy, as you can see, there's heavy evergreen screening. It's been there, and the neighbor who Ms. Stevenson is talking about came in, and then they realized, we staked it out, and then the stakes disappeared, but we won't say anything. And we just said, you know what, and we were already gonna keep it anyways, but we're just gonna put the fence, that's the existing fence there, it's gonna be 10 feet and more. So just put that there.
But just to avoid issues in future is why I'm asking.
Mm-hmm.
Because Who knows what people would ask for, frankly.
Well, there are not many people that have this kind of evergreen screening too. So that, I don't know if you can see it on here, if we somehow,
It still doesn't answer whose property and what's the line.
it's,
So your property extends to the flagpole lot, the 20-foot flagpole?
I'm sorry, one more time?
Your client's
Mm-hmm.
property line extends to the side of the 20-foot flagpole lot.
Correct. Can you,
Someone else. And the proposed pergola is 13.5 feet from that.
yes.
Okay, thank you.
So that is the neighbor's driveway. That's the flagpole of his property. Goes down to the gate. You see the call box. On the lower right-hand side, you can see the metal fencing, and we're putting our fencing, the new pool fencing is going to be inside of that, and inside another, like I said, 13.5 feet will be an open-air pergola.
May I ask a question? Melissa, I didn't understand the comment that you made about the people not using the driveway for enjoyment.
Oh, no, what I meant is nobody's going to set up a lounge chair and have a cocktail on the driveway. A driveway is for driving back and forth. So the property line, actually, our property line is about 3 feet off of their driveway.
Right.
So that's the only reason I say that. And we had in our first submission, we actually provided pictures of the area between the, can we zoom in on the overall? Oh, you're not in control again. Can we have control again? Thank you.
I can't control this.
No, you're now back in control. It's a zoom of the pergola area and the landscaping. Because right now you can't even see, if you walk down their driveway, you cannot even see the swimming pool. And we're going to put extensive, more screening in there. If you can read the notes and get closer.
Have they raised further objections?
No, we've not heard anything. I think they're happy we're moving the fence in and that we've settled who owns the trees, and I've heard no other, and we've been in front of this board with the pergola since the beginning.
Do any other board members have any questions?
If it's open to the board, I'm also able to open the area.
Alex, we didn't hear the last part.
He said he could put up an aerial.
I'd like to see it.
I just thought it might be helpful. This is the subject property, you can see here 370. The adjoining property is 400. And separating the flagpole, the flagpole lot that's behind 370. So that might clarify the property line.
I think so.
Chick, do you want to let us know your thoughts?
Sure.
So we've heard this over the course of quite a few meetings. The primary items that were identified at the last meeting had to do with the prior buffer, the 50-foot buffer to the north. My opinion on that is we now have a very specific planting plan that observes the 50-foot buffer, and the original condition of the ZBA approval from many years ago really just said that it was going to be left, and it wasn't specific. It didn't have a planting plan. And Mr. Greenwald, that was one of your two concerns at the last meeting. I think that this really provides specificity for the buffer planting plan. It will bring it into compliance with the prior decision, and it also has the benefit of an increased expanded wetland buffer around the wetland itself and a very detailed planting plan for the 50-foot area. So I think that's been addressed well, at least in my opinion. The other comment had to do with complying with a 50-foot wetland buffer, and obviously the applicant has taken that to heart since the last meeting just 2 weeks ago, expanded that to 50 foot, moved the fence, and again, provides a very detailed planting plan. We have reviewed all the plant materials and feel that it is appropriate from a scientific standpoint, and I believe that's been addressed as well in this submission. And I know that member Stevenson asked about the motor court, and that really has to do with the front yard variance that was requested to increase the wetland setback. So that has been reduced in size, the buffering has been increased, and again, the board heard the applicant's presentation on that. We also had comments from Mr. Lawrence, the house to the west the last time. He talked about two sets of rules, how do we kind of reconcile a green site versus a renovated site? He was really expressing gratitude for the board's detailed look at this. And, I think that we have really looked at this comprehensively to balance all of the issues, regain that 50-foot buffer, establish a greater buffer around the wetland, and balance these issues. So I think that, at least to my opinion, everything that we've requested and asked for since the last meeting and throughout this entire process has been provided in this submission. Of course, hearing from the public and any other board comments are very important, but those are my remarks at this time.
Would you accept the applicant's offer to provide a recordable covenant for the buffer?
Yeah,
Is that helpful?
we've been moving toward that, and I do have language that I can include if I'm so directed to prepare a permit, and it would be to prepare a covenant to the satisfaction of the ZBA council that would be recorded so that it remains on the land and is noted. We'll also have the covenant for, or at least the condition for performance of the planting and ensuring that we have a buffer that will be established with good survival and good health of the buffer plantings. So again, if you move forward and ask for me to prepare a permit, I would include those two conditions.
And is the primary attribute of the covenant that any purchaser of the property is on notice that they have to maintain this buffer area?
Yes, Jeffrey can comment on how it runs with the land, but that is my understanding from a legal standpoint, that it would run with the land. It would be a notification. We have done it in limited cases. I was actually looking through some earlier cases, and it hasn't been consistent, but it's probably something that we should be doing on a consistent basis. And I can also work with Jeffrey to come up with sample language to make it easier for that review, so that the applicant knows exactly what they have to do to comply with the conditions of the permit. So I think it's an excellent idea.
Thank you. Are there any members of the public who wish to be heard?
Mark, can I, if no public wants to speak, could we go back to the motor court? Because in looking, I drove around today, and in looking at the aerial view just now that they showed, oh, wait, this is a member of the public. I'll shut up till he's done.
We'll be back to you.
It's Mr. Lawrence.
Yes, I know. I feel like this is a regular occurrence for me. I'm feeling like a talk show host because I go around town and people tell me, oh, I saw you on television. So members of the board and other guests, once again, I appreciate the care and attention. I have 3 points I'd like to make, and I'm going to deliver them in the least important first. With regard to Melissa's comment of achieving 13.5, I think in there from the beginning, so why are we fussed? I'm going to take a strong objection to that point. From the get-go, I had said it shouldn't have two sets of rules. One was focused on the wetlands, but I always objected to the 13.5 feet. And my problem with what Melissa has indicated is that if the rule is you always get to count the flag lot space, then the rule should be so specified. It is my understanding that that is not the code. That the code is 30 feet from the border. So it is a variance, and it is distinctly asked for in the application. So I strongly object. The fact that I chose not to individually point that out does not mean in any way that I acquiesce, nor does it mean that I agree with it. I will just put it back to respectfully to the ZBA. It's either the rules or not. You either get to count the flag on driveway, or you don't. And it is, although Melissa's correct, I don't tend to have a cartel party in the Calhoun's driveway. It is directly closest to me, so I would have thought that I had in terms of quiet enjoyment, the ability to protect myself of not having something that is clearly out of code and must get a code because of the crisis. That's point one. Point two, just a matter of protocol for my own edification. I had asked, I sent a couple of emails and asked them if there were new plans drawn that had been submitted. I didn't get a response from the city, and I'm looking at the agenda for 27 was distributed, and that does not appear to reflect some of the changes here. So again, as a matter of protocol, how does that work? It's a member of the public, and everybody to comment. It would have been helpful to see what it was. And unless I'm misreading what was
Is it his mic? We can't hear as well as we'd like to.
Can't hear him? Moving the house closer to the road. That's a matter of protocol. It's a question of how it operates. And I suppose it goes back to whether in fact, and I don't mean to be presumptuous. So for you to turn. And third, I'm going to go back to my favorite set of issues. Chip has commented on them. I have always, from the beginning, said that I respect the process, I respect the diligence of the board. But again, I want to be very clear to Chip, that did not mean that I acquiesced. I said that I respected the board's process and diligence. Didn't mean that I said, therefore, okay, go with it. I still stand by my view of the statement that I don't think that we should have two sets of rules, and I stand by that. But as I said, I am respectful of the process with the ZBA, but it was not. But I don't want it left with the impression that I had said, okay, I'm fine. Because if you asked me today, I would say no, we shouldn't have two sets of rules. So 3 points. The pergola, I just want to disagree on. Number two, I don't understand the process of why I was not able to see documents in advance. And number three, I stand by my very philosophical, existential view of the true is. Thank you.
Thank you, Mr. Lawrence. Susan, did you want to?
Yes, now I have two questions. One is they're not actually asking for a variance for the pergola setback of 30 feet, even though it's 13.5 feet. Could someone clarify that?
Yeah, the variance request is 13.5 feet from the property line. I think, and I don't want to, I think the point was, if we're looking at our balancing, the benefit to the applicant compared to the detriment to the neighborhood, the detriment to the neighborhood is somewhat mitigated or lessened by the fact that the impact is on a driveway.
Okay. Next, so when I looked at the first map that they showed of the parking court at the front of the building. I noticed this the last time, that even if they reduce it by 5 feet, which isn't really very much in my head, there's an enormous amount of gravel that's put in the front of this house, close to the street, or visible from the street. And I've looked at the other neighboring properties, and I feel like I don't see that. Why are we doing this to these people? How can you, so the driveway proposed, so when you look at the amount of gravel, not just that, the driving in, driving out, the in and out, the big swath to my left, I don't know what that's, to the west, yes, there. That's bigger than the house, is it not? All this gravel? How many bedrooms? Is it required? I understand why that would be efficient for the people who would be living here, perhaps. But I don't think, I don't see why there has to be that much of, even if it's pervious with those pavers, the other part, the driveway in with the gates to the right, then the pervious part, but that's still gravel, and then to the left. And I don't know how you're supposed to get, how do you get in the garage even? Good question. I find it, so I wonder how there can be that much, why does there have to be that much gravel or driveway in front of this house? Because the other house is on Great Plains. I don't think, by the way, it's Great Plains Lane. I think it's Great Plains Road, although it's been listed that way the whole time. Is there an explanation for that? How many? So you need a certain number of parking places. I understand that. Right.
And that's exactly our number right there.
How many bedrooms are there?
4. So we have a required, what would be helpful maybe is, Alex, could we give actually control back to Alex and look at the aerial from a bigger perspective?
You know what, Melissa, bigger what?
No, I'm just want to, I just want to show you the character of the neighborhood, that there actually are similar situations on Great Plains.
Close to the road.
Yes, they are. We actually did an analysis between doing everything else the board has asked us. Can you actually zoom out a little more, Alex?
I don't know if you can.
Maybe we should just use ours. Actually, can we have control again? I had submitted to the board, as part of this last submission, 2 examples, because we had been asked a while ago if there were any other houses that didn't meet the required front yard setback, and we gave 2 examples. One was 300 Great Plains Road, and the other one is 55 Cooper's Neck Road, but it's actually used to be 180 Great Plains Road.
So Alex, can you zoom down?
Actually, no,
You can do it?
and I can give you.
There's a submission as part of their package that
Sure.
has the neighborhood analysis.
Okay.
It's in the board's file.
And this is actually a little bit more detailed with the actually addresses. Sorry.
Yes, sir. Can we put this on camera?
Yeah, we're gonna actually. Can we have control again, please? So I'll start with the 2 that I mentioned that were submitted. If you, actually, can you pull up the survey for either one of the 2 surveys we've had at the end of the day, 300 or 180? I'll start with that. So can you zoom in? So everybody probably knows this property. This is the property. You go down the street. Can you zoom in more to like really close? Keep going. And this is the the property. It's a tall, two-story, actually, it's a stucco two-story house. If you go up Great Plains, 180 Great Plains, and it's 9 feet from the property line.
It's historic.
I understand it's historic, but what I'm trying to
Well,
point out is
That's not what you're building from scratch.
Can I finish my presentation? What I'm trying to point out is the fact that there are similar parking courts like this, and on properties that are much larger. The other thing we have to remember is on this lot, we're in an R120, and this is a 70,000, it's an undersized lot for the neighborhood, impinged with a man-made pond and wetlands. So we're trying to give the clients required parking as well as a turnaround in case, say, mail guy comes in or FedEx or anything to turn around. So what we did is actually this gravel parking here is 18 feet from the property line, and it's 44 by 52 feet. And you can see it, right, we actually have a set of pictures that we can go through too, but we can go through that later. Let's go through this first. At 300 Great Plains Road, which is a little closer, that was a property that existed originally as a two-story house with a detached garage. The garage was, the ZBA granted a variance to connect them, and thereby making the garage now, can you alter it? The garage part of the main dwelling. The garage is, actually the house is now 35.2 feet from the property line to Halsey Neck and 75 feet to Great Plains. The existing parking court there, stone with a Belgian block, all stone, is 42 feet by 38 feet. We've also, and I gave the board a list, can we put up the, we have, oh no, we're not,
Never mind.
okay, we have, we've done an analysis, and we have 2 pages of all the properties that we have located that seem to be around the same setback as what we're asking for, give or take. They include 22 Great Plains Road, 70 Great Plains Road, 88 Great Plains Road, 224 Great Plains Road, 291 Great Plains Road, 300 Great Plains Road, and then actually one of the things we also noticed is that 367, which is right across the street from us, has a very, actually, can we zoom in on it? No, we're looking for our property over there. Yeah, right across. That's it. Yep. Zoom, zoom, zoom. They have a very substantial gravel parking right in front of their property, and they actually don't have any of the screening that we have. In fact, we have a photo that you actually, when you're standing on Great Plains Road, you look over, you see all the gravel. So I would like to think that we've really worked hard to screen that you won't be able to see anything on our property, gravel, house, anything when we're done with it. And we've hired a very good landscape firm, Ed Hollander Design. And
you're eliminating a curb cut, aren't you?
that was the last one. Thank you. So that talks about being neighborly, so we don't have a curb cut right next to the neighbor's driveway, so. Does that help?
Susan, do you have any more questions, or Julia?
I want to finish this line of questioning, and then I just have another point of clarification that I wanted to ask, if we're ready for that.
Yes.
So I'm curious to know, in terms of how this property, which is complicated for sure, and the now 3rd presentation that we've heard since last spring about it. Obviously, between the last meeting and this meeting, there have been a lot of adjustments. But also, the trustees have made a rule about properties being in compliance. Where does this fit with this 50-foot buffer? Before we talk about any of the other pieces, where are we with that new law and understanding, and what's going to be expected from this property? Jeff, is that something you can comment on?
I can, but I think actually Chick was
Yeah.
referring to that.
Let's have Chick.
Comments a bit.
And I've spoken directly to Tin about this the other morning. I walked in, And I think he was going to speak to Alex today about it too. He's like, I would be having you do exactly what you're doing right now. Go in front of the board, get your wetland special permit to restore, and you're actively restoring what before was just supposed to be left, alone. And through no fault of anyone, unfortunately, this was not caught before my client purchased it and got an updated C of O.
I appreciate that, but the point is that there's legislation that says
Mhm.
a board can't act when there's an existing violation, but I think what Chick was referring to, Mr. Voorhees was referring to before, was talking about the fact that the proposed modifications here, I think, would correct the prior issue, and in fact, be more specific, so that there would be a better control in the future. But I don't want to speak to you for Mr. Voorhees.
I may have
If you could
misspoke. That's exactly how Tin and I agreed. He said the same thing.
But just for the record's sake, so that
Okay,
it's
yeah.
clear, if it wasn't clear, if you could just review that again.
Yes, thank you, Jeffrey. That was my feeling exactly, that this really provides a more substantial planting plan. It observes the 50-foot buffer to the north on the property line, and it also increases the wetlands buffer. And it's much more specific than the original ZBA decision.
So then my question is, would that be curing, to the extent there was a violation before, or a lack of cooperation with the condition, would it be curing that issue, in your view?
It would cure the issue, in my view, correct.
So with that being said, my very, my layman's interpretation of my understanding of it is that don't we have to address, doesn't that have to be addressed before ZBA can talk about any of the other things that have been really put in front of us to consider on this property, that we shouldn't be considering it until that is in compliance? Am I correct about that?
So the question here is, should we require the planting plan prior to issuing the permit and the variances if we choose to? And if not, why not?
In my opinion, there was never a planting plan required by the prior ZBA decision. It was more vague. We can look at the exact terminology, but it said that the area would be left undisturbed or natural or something to that effect. So at this point, they could stop mowing the lawn, but it doesn't really get us anything to the extent that an approved planting plan under a wetland permit with the specifics that this has will get that for us. It will improve the situation, and as I said, the original condition, all they'd have to do is leave that area, and I don't think that really serves the purpose here that we're trying to do, and that is create the buffering, create the habitat, create the runoff control, expand the wetland buffer. To me, it's an improved situation over just leaving it, which is what the original condition was.
And if I may,
Chip, it wasn't left alone. It was, trees were cut down and grass was, they made it like a golf course.
That is true. I mean, we know what the conditions are now. So they didn't.
So it isn't that it was left alone. I understand that for some reason this fell through the cracks in terms of, there is on that map, it says buffer, like the Louisa May Alcott buffer, I forget what the woman's name was. And it shows, a dotted line in one of, maybe the first meeting. So it's not a figment of our imagination that there was something that was called a buffer. Isn't that true?
Not a figment at all. That's exactly what was shown on the plan and referenced in the decision.
I don't disagree with you, but I just would want to know, I personally, as a member of this board, do not want to be left out to dry if we are not actually doing what the law requires. That's, I think, what Julia is asking. What is our position here, right?
My question is so let's, I don't want to assume what anybody would say, but do we address just this planting issue and this 50-foot buffer, and do we have the agreed upon covenant put in place, and then does the rest of it get addressed by ZBA after that has been completed? That's really my question. And despite all the other conversation, I want to have an understanding of that and where we are.
It seems to me as though you would be requiring more than what the original decision involved.
Is it logistically possible to have the applicant do the Hollander planting plan and then issue the permit? Or what you're also saying is for them to do the planting plan, they would need a permit?
Well, that's a legitimate comment,
Okay.
yeah, because that wasn't specified in the original permit. So you are digging up lawn, which could have a potential impact on wetlands if it's not done correctly. We want silt fence, we want protection. So even that installation could have potential impacts, but if it's done according to the plan, those are mitigated.
So Julie, what I think Chick is explaining, in contrast with other cases, we would be confronting the prior conditions didn't really have a planting plan. So it's not as if we can require the applicant to comply with the prior conditions, because actually the applicant is going beyond the prior conditions and implementing a planting plan. So they're doing more than rectifying what wasn't done.
My understanding, Mark, is that the applicant has made that offer to us as well as a way to remediate the circumstances. So I'm not sure why we're kibitzing about the planting plan or not, or what was required. I have heard in the last 2 meetings that the applicant actually made that offer to us. But I also don't want to get hung up with this new legislation and say, okay, well now we can consider the pergola and the driveway and this and the fence, when in fact we're not supposed to be doing that until that is actually corrected and we've accepted their offer. That's, I just want to do it.
I hear you. Jeff, you want to
But
weigh in?
just to clarify one thing, the legislation, which was not in place when the application first came before the board, but has since been passed, but it does also have the following paragraph. It has the concept in it that there's a prohibition of a board going forward if there's an existing violation or a summons issued. But it also then goes on to say that the foregoing prohibition shall not preclude the processing of any application if all of the sums due the village have been paid. We're not talking about sums here. And it goes on to say, and substantially the sole purpose of processing is to cure the violations or to seek a variance from the Board of Appeals with regard to such violations. So that may not exactly be on point with our discussion here, but in part what they are doing is seeking to cure the existing violation. It will be the board's choice as to whether or not.
So if they want to do that, that's fine, but shouldn't they go ahead and do that and then come back to us with all the rest of it?
I think the concern that was being, and I'll leave this to the planners because it's in their area of expertise, and particularly Mr. Voorhees, so if he could comment on it. I think what Mr. Voorhees was saying is that it's difficult to do it that way because they're kind of interconnected. But I'll let Mr. Voorhees explain that this may be the way to cure that problem, that to substantially cure that problem is called for under the new legislation, is that they would need to follow through with the rest of the application. But Mr. Voorhees, can you respond
No,
to that?
that's very consistent with what I indicated before, and I agree with that.
So Chip, you're saying that the question of the pergola and the driveway is in part interdependent on the 50-foot buffer being restored? That all those decisions come together?
Well, we're looking at this as a package. The house is being moved farther from the wetlands. The wetlands buffer is being expanded. We're getting the 50-foot replaced. They've made their case to the board on the driveway, the motor court, and the pergola, and those are things that can be weighed. But ultimately, we are increasing the wetland setback of this house substantially. And so I guess there's the question of the plan itself, and if that meets the conditions of Chapter 116 for a wetland special permit. And then there's the question of a prior ZBA decision, and are they consistent with it? So I think we've talked about both of them, and this plan does improve environmental conditions on the site and cures the fact that that 50-foot buffer to the north was not left unmaintained.
But I think Ms. McCormick's question was, would it be possible to separate the dimensional variance, just the area variance being sought, for example, for the pergola, while dealing with the wetlands permit issue first, and then once that's confirmed, then the board could rule on the area variance? Could those be separated out in from a planning perspective?
I don't quite follow.
Well,
You mean
they're
in order
asking-
to cure the violation?
Yes.
Or just as a matter of how the ZBA looks at those variances?
And
Yes.
into this new legislation. That's that's in part my concern. That's why I'm
Chick,
bringing
I have
it
a
up.
question for you. From a logistical standpoint, and considering the investment that the homeowner's about to make in planting material, doesn't it make more sense to do the construction project first and then do all the revegetation? 'Cause if we're gonna plant all that stuff next week, say, it's gotta survive the winter and it's got to survive a big construction project. So it seems to me as if, legislation aside, the planting should be the last thing done next spring.
Yeah, they have grading that's going to take place. So
Right.
the grading has to be completed before they can do the planting. I think we can let the applicant comment, but I think it's optimistic to think that this would take place this fall at this point, with all the work that's proposed, the demolition, the grading, the erosion control, and then the planting. So you're correct in terms of sequence. And again, the applicants can speak to the construction management of this, but I agree with you. I think all of those site improvements and the earthwork has to be done first before you would do the planting.
If that's the case, then I just want to go back to what the legislation provides, because that would then suggest that what's being done would be substantially the sole purpose of the processing to cure the violations. Because if the idea is that the planting can't be done until the construction is done, we would end up in a sort of never-ending
Endless circle.
So having read the legislation again in conjunction with what was just discussed, I think in my opinion, that suggested program fits with the legislation. The board, in processing it, would be, in effect, dealing with the fact that that's the only way to get past the violation at that point, if that's what's being explained.
Let me just ask this as well, as I was thinking about, because we're concerned about enforcement mechanisms.
Right.
If the applicant's offering a recordable covenant,
Right.
is the village or is the zoning board a beneficiary of that covenant, so that if for some reason that buffer was not in place,
Yes,
we could enforce the covenant?
and it can be drafted accordingly.
Does that help, Julia?
I think that the enforcement of the legislation is clumsy, and this area of land has been out of compliance for a very long period of time, and I appreciate very much the thoughtful presentation and plans that the homeowner has put in place and the professionals he's secured. But I also think that I feel as though we're hemmed in too, and if this is supposed to be corrected, then I'm not comfortable making a decision on all aspects that we're being asked for right now. Part of it, yes, I'd be comfortable making a decision, but I don't think I'm comfortable making a decision on all of it, given this new legislation that's in place.
Chick, I have another question for you. The requirement in place that they're not conforming to is just that 50-foot buffer be unmaintained, right?
Yes.
And that's what you're talking about, or this planting plan being much more specific. So isn't maintained versus unmaintained just a matter of them saying, and I know it's October, but we're not mowing the lawn anymore?
Yeah, in effect, I think that's really all that was contemplated by that original condition. I mean, we do know that there was an ornament, what looked like an ornamental tree that was removed, and the applicant can speak to why or why not that was removed. But other than that, I think it's really just that you wouldn't maintain it, so it would go wild.
Well,
So
for-
Chip, you're maintaining, I don't, it appears to me that they didn't leave it alone for however many years, that it was mowed and God knows what else. They took down trees, the Smurfs Adobe House Department, which I call it, there's more than one of those, these humps. And that they weren't supposed to be mowing it all the way over to the berm of the adjacent property. So I don't agree that it was just left alone. It's too late now. It wasn't left alone in my head. And so the remediation is that they will plant the proper vegetation and maintain it in a 50-foot wide buffer. So I understand why they wouldn't be able to do that until they complete the construction of the house and every other thing that they want, if they're gonna get it. And then do the planting, the grading. I think that that is reasonable, but it needs to be carefully written so that that shows that that is the remediation that we're seeking, and that, or the remediation we're seeking would be cured, I would say, by that. I don't agree that that land was left for however many years since the Louisa May Alcott, I call it, I don't know what the woman's name was, buffer was instated. I just don't.
No, I
don't-
didn't state that. If I implied that, that
You
was
did,
not,
to me.
that's not what I intended.
Okay, I think that.
The conditions are the conditions. It has been
Right,
maintained.
I agree with that.
It's
Those
been
are good
cut.
conditions
Right.
Where something was left for however many years, because there's nothing growing on it, frankly. Everything that was growing on it is gone.
I agree with what you're saying. If I
Okay,
said something different before, that was not intended.
But why don't we leave this for our decision? I think our purpose tonight is, do we have any more questions for the applicant? And we can, deliberate whether to grant the wetlands permit, whether to grant the pergola variance, in the course of how our decision is going to be written. But for right now, I'm leaning toward closing the public hearing for all purposes, but I want to have all of our questions asked and answered before I do that.
Mr. Lawrence is raising his hand, I don't know if you can see.
Can I actually?
Yes, Mr. Chairman, can you see me and hear me?
Yes.
Okay, thank you again, and I want to make 2 points. One, not to belabor, but on the question of the pergola, one of the observations that one of the members of the committee made was that because they were being sensitive on the wetland setback, that some consideration has been made. If you look closely at what I have was distributed for the agenda, there are 2 different places where variance is requested. In one, it says, at the beginning, it says, which is a relief from section 116-11 side yard setback, which is decreased setback from 30 feet required to 13.5. Then further down in 3C, it deals with a wetland. My observation is that I think the point that's being made is you're focusing on 3C, which is in consideration. My point is they don't require it. This is not. It doesn't exist. They're squeezing a lot of stuff onto this. It's new construction. As a neighbor, I do believe impacts me. So I can understand the point that's made on 3C, but I challenge the decision vis-a-vis 1, which relates to section 116-11, which is the 13.5. My position is that there is no reason that I understand of why that should be granted. And it's a technical point, but it's different from the wetland point, and I stand firmly on it, because either we have the zoning setbacks, or we
And we agree with you, Mr. Lawrence. We understand that they are separate, and the board is also considering the possibility of granting a wetlands permit and a front yard variance for the house, but not a variance for the pergola. So we do see them as separate and distinct.
I just wanted to make sure they weren't lost, because I misunderstood the comment, because I would object strongly to the section 116-11. The second point I just would make is, I listened carefully to the very thoughtful discussion about how you cure these elements and whether you require a planting first. I would just make a simple observation that if and by the way, Ms. Stevenson is 100% correct. I live next door. That thing has been maintained, mowed, etc. But if the applicant is allowed to tear down the house prior to any of the vegetation remediation, we all know what construction sites look like. They look like the surface of the moon. It's going to then cause all that drainage to ultimately drift into the pond. I understand there were some attempts to create vinyl barriers, but I would have thought that the right answer would have been to have required some of the vegetation remediation first, so it protects the pond, which then runs off into the creek and ultimately into Shinnecock Bay. So, again, as I've said repeatedly, I respect the ZBA thoughtful discussion. I mean, I would agree, but this is why we have processes like these. We put ourselves in the hand of the people that are empowered to deal with it. But I would strongly urge that consideration in terms of the construction aspect, which is if you're going to make the determination of open fine, this actually makes a bad situation better. Then there's really the question that has to do with the sequencing. I would argue you want the wetlands buffer put in first. Otherwise, I think you're going to have serious damage done. You may not be as expert as Chip on this point, but I've seen a lot of construction sites and look like Thank you.
No, thank you. And I do think Chick will, one way or the other, implement a construction methodology that protects the wetlands. Chick, that's part of our wetlands permit, isn't it?
Yes, it typically is. I was just checking my files, and I thought one was submitted. Do you recall? I'm sorry.
Yeah,
Construction methodology.
We don't have a construction, we did.
All right, we should have that, and we should also have erosion control measures
That we have.
for the
yes.
purpose
I
of
mean,
the
if you
plan.
go, again, because I live next door to it, I drive by it all the time, so I see it. It really, there is nothing right now buffering to the pond. So, again, if in the judgment of the ZBA, this is the right thing to do, I would have liked to see a very fulsome protection of the pond, which to my mind would have vegetation put in first.
I think though, Mr. Lawrence, just want to clarify, and maybe Melissa will do this better than me, but the 50-foot variance that or buffer that we're talking about right now isn't around the pond. It was conditional previously along the eastern property line.
And actually, a 50-foot buffer around the pond would go through the existing house. The
Right.
existing house is located 34 feet from the wetlands.
Well, okay, but the map that's up right now shows proposed 50-foot wetland buffer area, right?
What, I
Yeah,
don't
and
know
that's
what map
being
you're looking
applied
at.
to for this new construction.
Right.
What we're concerned with about enforcement is how they're slightly out of compliance right now for a 50-foot buffer along the eastern property line, furthest from your property. It's not really,
Yes, no, and I understand that, and I understand that the technical issue around that, but if the committee in its judgment is going to make the determination to grant the wetlands, I would hope that part and parcel of that is the protection of that area, the dredge pond, which again drains out ultimately into Shinnecock Bay. And while, yes, you're dealing with the original 50-foot concept on the east side, on the it's got that whole buffer around the pond, and I would have, and I'm not expert on it, I just know what construction sites look like. I would have preferred to have seen the wetland buffer area.
But Mr. Lawrence, we're asking Mr. Voorhees to, which he does in many of these instances, to create like a plan for protecting, when they're working, protecting the wetlands that they're, that are around, that there are elaborate procedures. And that would not include putting in the elaborate landscaping so it would die before its time. I do trust that Chip will come up with an appropriate plan, all kinds of things like how they get dirt out and, this is usually part of the process, and we're asking him to do that, so I wouldn't be too worried.
And I respect that the board has brought on an environmental consultant and looked at that. And I didn't, Ms. Stevenson, I didn't mean to imply otherwise.
Thank you, Mr. Lawrence.
Thank you for the opportunity.
Can I address some of the
Of
items?
course.
First of all, I just want to go over that I think we're mixing apples and oranges, just semantic-wise. I want to get cleared that what was approved in 1997 for the swimming pool installation was a 20-foot wetlands buffer around the pond, which was a man-made pond just built a couple decades earlier, and a 50-foot natural area. It was never called a buffer. It was a natural area that was supposed to be left undisturbed. What we're doing is we're proposing to put a 50-foot wetlands buffer, restore that 50-foot area, and call it a buffer and actually covenant it. So it's actually, as Chick was saying, Mr. Voorhees was saying, it's a better condition and it'll run with the property because it'll be part of the deed. The original 20-foot wetlands buffer wasn't even part of the deed. So you're ending up with, like I said, 47% of the property is going to be natural habitat. Again, for an undersized lot in this area, I think that's pretty impressive. The other thing I'd like to state about, I know I've been in front of this board for over 30 years. I hate to date myself, but I also know this board hates when you come back and forth with piecemeal, so we try to do it all together. If we could put up the compliance thing. The other reason we're here for the pergola is if you remember correctly, because we have this pond, this man-made pond. Is it up? Oh, there we go. Okay. We also need a wetlands permit for the pergola. So, and we put it as far away, which is what the board asked for. Again, I think Mr. Greenwald was very true about looking at the balancing act. We have gotten similar variances for accessory structures. Can we put up the pergola? I mean, this is a very simple pergola, only used on a seasonal basis, not enclosed, well screened. There it is. I don't think you could make it any more simpler. And so that's what we're going for, not just the variance, but also for a wetlands permit. So we're trying to put it all together. So we're hoping with one approval from this board, we can bring this site in compliance, build a house that's 20 feet further from the wetlands, establish a wetlands buffer, put in an IA system, get rid of a second curb cut, and have a house that's actually within 500 square feet of the existing GFA of the existing house. I mean, we're not anywhere close to maxing it out. I think the board's been very helpful with offering to provide the front yard variance. And I really think it's a win-win for both the village and the client. And if possible, we would like to close this tonight, and whatever, if you want us to provide any other information, we're more than happy to submit it.
Just a quick point. You're covenanting both the
We're willing to,
natural area
correct,
and the wetlands buffer?
correct.
Not, okay.
Both. So it actually ends up with a like over 75-foot average width, even though you hate me saying average width. Again, 47% of the property.
I would like to motion to close for all purposes, case number 3132, 370 Great Plains Lane. Can I have a second?
Second that.
And all in favor of closing for all purposes, 370 Great Plains Lane, please say aye.
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 Okay. Moving on, we have a motion to accept the applicant's request for adjournment to November 15th in case number 3144, Stephen Hickey, 1377 Meadow Lane. Can I have a second?
Second.
And all in favor of accepting the applicant's request for adjournment to November 15th in case number 3144, please say aye.
Aye.
So we move on to case number 3147, Andrew Fleiss, 64 Down East Lane.
Jim Walker from InterScience. I'm here with Carl Benincasa. I'd like to cut to the chase. I think we have a reasonable solution to the opposition from the adjoining property owner. I have this big presentation that we prepared.
Same as what was submitted last
Yeah,
time.
you don't have to look at it if you don't want to. I would like to move quick, Mark, because I think some of this stuff is going to fall away. We will present all the information. If you have questions, just stop me. So the first items that we submitted, it's my letter of October 20th to Carl Benincasa, is the subdivision maps, the underlying maps for this property and the adjoining properties, and the legal documents that accompany it, including the drainage easement for the arm of Hetty Creek. We submitted a number of air photos which document the conditions in the drainage easement and for the subdivision. These are background items that you may not really need to study, but if you have any particular questions, we looked at all the air photos, we looked at all the subdivision maps and legal documents, and we also submitted at that time the trustee's permit. Trustee's permit was granted for the dock assembly that was shown. Subsequently, we've done a couple of additional things. Carl has drawn up a letter to the town trustees to discuss issues with the adjoining property owner. And then I submitted on Tuesday our summary of things that we are willing to do to resolve any issues remaining with the village and with the adjoining property owner. The first item on my October 24th cover letter is a staking diagram. I staked it. I measured 32 feet from the monument, and I measured 10 feet off the property line, which is marked by a fence. And I put the stake in where the proposed kayak dock would go, and subsequently sent that off to Pat Sacafico so a surveyor stake could be placed at that location by a licensed professional. We have provided to the village the variance standards, the normal discussion that's required for a variance, and Carl can address those issues. And before we get to the issues that Carl will discuss regarding the variance, I want to remind the board that I got the permits at 405 Captain's Neck Lane. I'm familiar with the property. I've been there recently. I also am familiar and went down to check the conditions at 64 Down East Lane, because Chick Voorhees said there was some trees down at the bottom of the lawn area, and I went there, and they're not there. If you look in the most recent air photo that we gave the board, they were there. So Chick either was looking at the air photo or has a recollection of that property before certain things were done. But when my client took title to the property, there was no vegetation left at the bottom of the lawn down by the fence. So I told Andrew Fleiss that it would be a good mitigation measure and a reasonable thing to offer a single row of native shrubs along the entire frontage of the bottom of the lawn down by the wire fence. So that's in the correspondence, it's in writing, and the board has that for tonight. The last thing that I would like to do before we ask Carl to come up and discuss variance standards is property owners willing to reverse the kayak drop platform to the east and to try to mitigate any potential conflict with the property owner at 405 Captain's Neck Lane. That is the last item. I submitted it on Tuesday. It is a full set of plans, and it would then, after the board made a decision on the project, go to the Army Corps of Engineers, New York State DEC, and Department of State. And that's my abbreviated presentation. There's a lot of material that we submitted. If you have any particular questions, I'd be happy to answer them. Other than that, I'm going to turn it over to Carl.
No, let's go ahead. Thank you.
Good evening, members of the board. Good to see you all. As Jim noted, the application has been amended in one key respect, and that is that the platform has reversed its direction and now faces eastward. I just want to make sure you all have the revised plan in front of you that was submitted earlier this week.
Submitted Tuesday before 12.
So that addresses a good degree of the opposition's concerns, and I've had an opportunity to speak with Ms. Reichert before the board, and I'll let her speak to her client's position with respect to this new orientation. As for the variance, historically, or there are examples of these structures being permitted within setbacks without variances from this board. A good example is Captain's Neck Lane, Mr. Lansing's property, which Jim did not 3 years ago, 2 years ago? 2019. The trustees have always been given primary jurisdiction with respect to the town trustees with respect to these structures. They are given the authority under the patent, which stems back to before this was a country. And that patent really addresses riparian rights. And I think the reason, I will go through the variance standards, but I just wanted to bring this up. I think the reason these have been allowed without variances is because of the doctrine of riparian rights. And that is when a landowner has a boundary that is against a navigable waterway, they are afforded certain rights to obtain access to navigable waters. The overarching policy of the law is that they should be afforded rights for navigation and trade and travel, and these endure to today. It is irrelevant who owns the bottomlands. And while the bottomlands were originally owned by the Crown, then the state, and through the state's inheritance of the patent exercised by the Board of Trustees, they cannot deny access to a riparian owner, which Mr. Fleiss, the owner of 64 Down East Lane, is. There's an aerial from 1930, which is up on the board. There was a question about whether this was a naturally occurring seaward boundary. And if you look, this is an aerial from 1930, long before this area was developed. And you can see that the creek existed. This channel of the creek existed well before any development was there, when it was a vacant farm field. In fact, you can see evidence of Hetty Creek going up almost to Captain's Neck Road back in time. In any event, as you can see, the darker portions of the waterway showing navigable waters are clearly touching this property, and they've existed since at least 1930. So we're talking about 90 years going back, and clearly well before then. So this is a navigable water. As such, riparian rights attach. As such, there are vested rights of the landowner in obtaining access to navigable waters through the use and the construction of various improvements, including docks, piers, wharfs, and actually dredging, all fall into the umbrella of rights, or the panoply of rights, as the Court of Appeals has labeled it, of riparian right owners. So in considering the doctrine of riparian rights, it's understandable that zoning boards have been, seated or been acquiesced in a good deal to these setbacks because they are faced with, and I'll let your counsel certainly instruct you on this or advise you on this, but they are faced with that overarching legal principle. There is case law that discusses how zoning boards deal with riparian rights, and in fact, zoning laws do have credit, and they do have application. But nothing can be done to prohibit the access of a riparian landowner from accessing navigable water through these improvements. That said, turning to the variance standards, again, we're seeking for relief from side yard setbacks. We're in an R120 district, so the minimum is 35 feet. We are proposing a dock and catwalk that is 10 feet from the western side yard, and a kayak rack, which is 6 feet. And you'll notice the kayak rack has been relocated to be wholly outside of the wetlands. The first standard is, does the area variance produce an undesirable change in the character of the neighborhood? Well, that 10 feet setback is not something that we just came up with. That is the setback outlined by the trustees in their blue book. And the trustees have approved and regulate the bulk of docks, all the docks in the town of Southampton. So to say that requesting this relief would create a substantial change or an undesirable change in the neighborhood would be failing to take into account the fact that every dock in the town has been approved subject to that 10-foot standard. And in fact, the dock right across the creek, the dock currently owned by Ms. Reichert's client, is 10 feet from the side yard setback. So that proposes no change in the character of the neighborhood. Can the benefit sought by the applicant be achieved by some method other than this? Well, yes, we could push it a little bit down the creek, but that creates implications which I think make it more desirable to leave it where we are. As you get further down the creek, in a more recent area will show you that the navigable waterways, the depth of water decreases. And as the water decreases, the marsh increases. So to push it down the creek, not only would it limit his access to navigable water, which again is preserved by riparian rights, it would also risk enhanced disturbance of the wetlands. So possibly speaking, yes, we can move it. Practically, I don't think there is a good argument to move it any more east than we have proposed. Is it substantial? Well, it's been approved by the Board of Trustees in its current location. The property, the design is cognizant of the wetlands. And again, when considering the general standard of the Board of Trustees and the location of docks in the immediate vicinity, I don't think you can say this is substantial. Now, you might say, given the amount of relief requesting, it's substantial, but again, taking into account the entirety of the circumstances, it would be hard-pressed to say that this is a substantial request rather than a reasonable one. Will the granting of the proposed variance have an adverse effect or impact on the physical environmental conditions in the neighborhood? Again, we're here partially, primarily for a wetlands permit. So you're considering the disturbance. Mr. Voorhees is also considering that. We're taking measures necessary to limit the impact to the wetlands in a way that both preserves his riparian rights, his rights to the dock, his rights to access navigable water, and his limit to and limits his impact to the wetlands on site. Is it self-created? Obviously, it's not self-created. The limits of that creek have been in existence well before my client took title about a year ago. There is, elsewhere in the code, there's not really strong mention of dock in the zoning code, which is obviously the code you're concerned with today, but I just wanted to point out that the village has ceded jurisdiction on docks in other chapters, specifically Chapter 49, which is the coastal erosion hazard area. Not implicated here. But I did want to note that the village noted that a dock is unregulated under village code in the coastal erosion hazard area. So there is examples of the village ceding some jurisdiction on the dock. That's with respect to the variance request relief. As to the neighbors, now you've heard from one neighbor, and I think we've come to a resolution that is acceptable to that neighbor. But the neighbor immediately to the west at 95 Down East Lane wrote a letter, which I'll read into the record now. Our firm, Southampton RE Partners LLC, owns the property at 95 Down East Lane. The property immediately to the west of, adjacent to 94 Down East Lane, is the property owned by 95 Down East Lane is the property owned by the Fleiss family at 64 Down East Lane. It has come to my attention the Fleiss family has proposed a dock application under review by the Village of Southampton. I am writing this letter in support of the Fleiss family's proposed dock application. I have received their plans and believe them to be prudent and courteous of neighbors. Further, I know the Fleiss family personally and have found them to be sympathetic, responsible, and kind homeowners and neighbors. So, arguably, the neighbor most affected by the relief requested and the application submitted is fully in support. As Jim noted, there was a letter I wrote to Mark McRedmond, who's the attorney for the Southampton Town Trustees. It does cite case law with respect to riparian rights and addresses some of the comments raised by the opposition in this matter. That was submitted to you on Tuesday. So you are free to refer to that if you have any additional questions. I am also here, of course, if you have additional questions. Thank you.
Thank you.
Shall I go?
Sure, absolutely, thank you.
Good evening, everyone. My name is Martha Reichert from the law firm of Toomey, Latham, Shea, Kelly, Dubin, and Quartararo, 33 West 2nd Street, Riverhead, New York. I am here on behalf of my client, Mr. Sims Lansing, who is the owner of 405 Captain's Neck Lane. Is it possible to get that aerial back up? So I do want to offer a slight correction. That is not the 1930 aerial. That is the 1962 aerial, which you can see from the check mark, the second line up from the bottom that says 1962. We've reviewed the revised plans that were submitted by the applicant, and we appreciate the efforts they took to shift their drop platform further east, because I do believe that will alleviate some of the concerns regarding navigation issues between the two docks on that narrow creek. Well, my intention tonight is not to go into a long diatribe about riparian rights. I am the former counsel to the trustees of the freeholders and commonalty of the town of Southampton, so it's an area that I have a certain amount of familiarity with. One of the things that distinguishes this particular creek is the fact that it is a dug channel, right? There is a drainage easement that runs to the benefit of the village, which is along the shoreline where the dock is proposed. And so that while there are riparian rights and we recognize them for all waterfront owners, it becomes a little bit less clear when you're dealing with an artificial creek. And so I would sort of like to bring my comments towards the location of the dock is much improved, but we still have a concern about the regular wharfing or berthing, sorry, not wharfing, but berthing of vessels at that platform. I personally visited the site. I actually got in the water, went across the marsh. I took measurements. And so our concern becomes about whether or not a boat, a vessel of any size, will be berthed there on a regular basis. We have no problem with the dropping off and picking up of passengers, but our concern is that at low tide, a good portion of that edge of marsh is exposed. And to have a vessel sit on it would be a trespass on my client's bottomlands, and that does not fall under the panoply of riparian rights, to leave something every 12 hours on the bottomlands. And so in addition to sort of the property rights that run towards my client, we're also concerned about the impact of having anything sit on those, on the marsh, on the bottomlands on a regular basis. So we would ask this board that if they are to move forward, to consider as a condition of approval that there be a restriction on the regular berthing of a vessel in that creek. And that's really the extent of my comments until I sort of hear what Chick has to say about his review.
On the same page. Chick, can we hear from you?
Thank you. I just wanted to kind of go down through some of the questions from the last meeting and how they've been addressed at this time. We did ask about trees, and Jim is representing that there are no trees there. They do show up on aerial photographs, so I don't know the history with respect to that. But if there were trees, we would look to retain them and avoid them. I did comment that the dock was not perpendicular to the wetlands, and that could have a greater impact on wetlands. What I'm hearing is that the penetration of light and the ability of marsh vegetation to thrive under this structure based on the height and the through-flow decking should allow the wetlands to remain. I did comment that the kayak rack was immediately next to the wetlands, and it looks to me, notwithstanding what Carl said, that there still is a small corner that's within the wetlands, at least on that reoriented diagram. But I would seek to have that moved farther from the wetlands if possible. And Jim, Mr. Walker indicated that the applicant is proposing additional plantings for the wetland buffer. Certainly the kayak rack should be located outside of that area. And one of my comments before was to help to mitigate or help to justify this project, that some additional expansion of the wetland buffer, this is landward of the flagged wetlands, could be considered. And that might, again, be used for partial justification, and it's good for the wetlands. I think that Ms. Reichert's comments about water depth are pretty much on target, but I haven't reconciled yet how best to access the waterway. If you look at the diagram, the dock ends basically, and this shows in the cross-section very well, but I see depths of 0.2 at mean low water, and the mean low water mark is beyond the actual termination of the dock structure, the catwalk. So I think the function comes into some consideration, and also what I said before, that the actual structure itself is terminating within the wetlands, not at the edge of the waterway. So it would push it out a little bit more, and it would require some calculations on the width of the waterway that Jim has presented before, but extending this a little bit farther, if it's possible, and I just want to hear from the applicant why or why not that wouldn't be possible. I'd rather see more of this structure, especially the terminus, out of the actual wetlands. We can certainly talk about the proximity of the dock itself to the property line. That is one of the requested variances. I think Mr. Benincasa's testimony in his letter is fairly compelling, and so we may want some time to consider that. But it is true that the trustees typically would look for this type of setback. It's consistent with other decisions, and I think, again, Mr. Benincasa's letter speaks to that, as did his testimony. One thing with respect to that is the kayak rack itself, I assume it's 4 feet wide because it's asking for a 6 foot to the property line variance. And so I think an obvious question would be, why couldn't that be flipped over to the other side, more on the interior of the property, if we're not going to reorient this completely? And as far as reorientation, I see pros and cons to that. If you do move it farther to what would be the east, the waterway does narrow some, and the wetlands are a little bit wider. So this, if we can overcome or at least justify the side yard variance based on the testimony that the applicant has provided, this may not be a bad location, again, because of the width of the wetlands expanding and the fact that access to the waterway would be further curtailed by going into a narrower section of the waterway. So I think that's something we can talk about as far as the balance. But Again, the terminus of the dock, trying to get that out of the wetlands and perhaps in a more functional area, flipping the kayak rack and moving it farther from the wetlands, expanding the buffer, and I don't think any plans have been presented by Mr. Walker that show what he's represented for plantings along the wetland line. Those would be my comments at this time. They're quite consistent with what we talked about at the last meeting. Some of these have been given consideration, but I think some of the comments also still stand.
Do any board members have any questions or comments?
I have a question. It says in the application, this is for use by canoe, kayak, and dinghy. How is that possible in this shallow water? The dinghy part. Is that just standard or?
This type of dock is called a dinghy dock. Kayaks are more recent. I've been pushing permits for 38 years, and I worked for the trustees for the last 20 years. I'm very familiar with the terminology and the styles of docks. They've changed a lot, very radically changed. These always were called dinghy docks. However, people use them now for kayaks, canoes, and stand-up paddleboards. And the way they're designed is you put a ladder at the end, you put a drop platform at the end, and it's close to the water. You drop your canoe or kayak into the water, and you step down the ladder and you sit in your canoe and kayak. Mr. Fleiss has 3 children. This is a dock that's designed for family use. That's what it's designed for. It's important to note that the entire dock has to be through-flow decking, 60% light transmissive. All right, it's transmissive. So the plants will grow just fine underneath the dock. When it comes to the kayak rack is 3 2x6s. The 3 2x6s allow. If you don't want to hear it, you can just tell me to.
No, I'm just asking.
It's used for kayaks and canoes. And they.
Where's the dinghy? It's in the application. I didn't make this up.
These kind
That's
of.
what I'm asking.
These
If
kind
there's
of
no
docks are
room for
always
dinghy
called
to be
dinghy
in there.
docks.
What?
These kind of docks were always called dinghy docks. That's
No,
the
that's not what it's, this is the application question. A special permit, and then it's been written in for use by canoe, kayak, or dinghy.
okay.
That's what I'm asking you, not, I just want to know, because I thought there was some,
They're used for kayaks and canoes and stand-up paddleboards. They're used all over the east end of.
I'm not asking that. On the application, it says dinghy, so why is that in there? That's what I'm asking.
Because they're called dinghy docks. They've always been called dinghy docks, and if that offends you, I'm sorry.
No, it doesn't answer my question, sir.
We'll take it out of the application.
I didn't make the application, excuse me. It's your application.
No kidding.
I'm not allowed to take things out of your application.
Okay, I stand corrected.
That is really out of order, sir. I'm asking a question because I read your application.
They're called dinghy docks. It's intended for use by a kayak, a canoe, or a upright paddleboard. And we will submit a planting plan to the village for additional plantings at the buffer. It's important to note on this particular project where the dock is proposed is where the people have always walked down to the water. The first time I went there was a path to the water. There's still a path to the water. We're trying to put a dock there. I can understand the comments about installing a piling at the edge of the marsh. However, we don't want to go to the property line of Mr. Lansing. We want to stop at the edge of the marsh and install 2 4x4s to hold the kayak dock, and that will cause a short-term modest impact, but I don't think we're going out into the creek any further. There is a 1/3 rule at the trustees. The width of the creek is approximately 24 feet. Sims Lansing stock goes out 8 feet into the water. The other 16 feet is open. It's irrelevant. The property owner wants to stop at the south property line, so there isn't a conflict between him and his neighbor. We're asking for a kayak dock. It's completely light penetrable. There'll be planting plants installed along the edge of the lawn, and I think Andrew Fleiss has done a nice job of being flexible with the design and coming up with information to address all the village concerns.
Chick, what buffer width would you recommend?
It's, always tough to put a number on those types of things, but there is lawn pretty much down to the edge of wetlands.
There's lawn down to the
think a
fence.
20 foot would be a very good effort. If less, then I'd want to hear, the applicant's logic as to why some additional buffer, couldn't be provided. It looks like the pool, other improvements are well upland from the wetland area. So there seems to be ample room.
And when you're referring to a buffer, you're referring to the need for a planting plan?
Yeah, and Jim has just indicated that they would provide something, so I think it's just a question of providing that direction. I do see that there is a wire fence that kind of spans the property line near the wetlands. And
Chick, if you
that
talk,
might be a consideration as well,
if
to
you,
plant that area within the fence toward the wetland.
if you're talking about 20 feet from the wetlands line, that is a reasonable request.
Would that involve moving the fence then? To allow
I'd have to look at the
wildlife?
fence and see if it's worth retaining. The problem with fences in people's lifestyle is this property is used by 3 children. They have trampolines and stuff all over the front lawn. We need to have some kind of fence there, and 20 feet from the wetlands line is reasonable. There's some phragmites in between the wetlands line and the fence, and I think that's fair game. Groundsel bush, and then above it, something more attractive like winterberry will be a nice edge to the residential. It'll be a nice transition between the wetlands and the lawn and the landscape. I think that's fine. We'll give it to you right away.
So my question has more to do, and Jeffrey, maybe you can weigh in on this. Am I looking at the right, when I'm looking at the historical maps, it's Beatrice Glass? That's this property?
You might be the only person that looked at them, Mark. The original subdivision is Frentz, F-R-E-N-T-Z. And Ted Squires drew this map in 1967, and then it was amended slightly, and in 1969 it appears to be finalized. I got these maps from Squires and Holden. They had all the original documentation on it.
It's great, and I think then, is it also parcel C on the 1967 Squires map?
Okay. Felsky and Oltarsh shows up on the 1967 map. This is 64 down East Lane. Parcel C was a different shape in the original subdivision.
Mhm.
The subdivision map seemed to go through a series of amendments. Am I answering your question, Mark?
Well, I mean, I just want to make sure I have the right property, because then what's the 20-foot easement? Because my concern or my question is, this property is not owned to the water.
Well, that's why we looked at the 1962 air photo with the property overlain on top of it, because it shows the water existing in 1962.
No, and there may be water there, but is that water on the easement, and do we have the terms of the easement? Who,
The easement's all there.
right, so who owns the property on which the easement runs?
The fee title to 64 Down East Lane is owned by Andrew Fleiss. The opposite side is owned by Sims Lansing. They both have drainage easement imposed upon them. The drainage easement goes down the arm of Hetty Creek. Goes down to the arm of Hetty Creek.
The properties as well.
The drainage easement also changed over the time frame that this subdivision was reviewed and approved by the village back in the 60s. But the drainage easement is shown properly on the current survey.
Does the easement bar construction?
No, it's easement to the village of Southampton to allow them to use that area for drainage.
So if the village needed to dredge that or otherwise increase the drainage, the proposed dock would be in conflict with their ability to do so?
Number one, it wasn't for dredging, it was for pipes. And the drainage, the easement that was granted is used. It drains water from Captain's Neck and 405 it drains the water from Captain's Neck Lane and Down East Lane through the easements that were provided in the subdivision. Number
certainly
two,
the village has the
village isn't
right
going to
to-
get approval to dredge any more than a private party would. In other words, yes, the drainage easement is there, but there's no conflict. There's not going to be dredging in this easement or pipes being installed that are new.
But my point is, what if the village decided that it was in their best interest to modify the conditions of the easement so that drainage could be increased or decreased or changed in some manner?
Well, they could run drainage pipes down the easement without conflicting with the dock, but I think that's impractical.
Jeff, do you know is the easement a written document, or is it just showing on the maps?
The easement is,
You have it.
Submitted.
It
Okay,
was-
so- No, I thought it was written, but so is there anything, is the property then owned by the village?
The easement is granted to the village.
So the easement's granted to the village, the property owner is, at that time, perhaps Beatrice Glass. I just want to make sure they have fee title.
What it was, at the time that it was drafted, it was from Norman Felsky,
Okay,
and I believe that that is the property that then was subsequently transferred to Glass.
okay, that's my question, whether they have fee title down to what is the water now, or, and you're saying that property owner at the time granted to the village an easement.
Yes.
For what purpose was the easement?
So it was for the purpose of use, maintain, repair, and to install drainage pipes thereunder for the following described premises.
So I guess the question I'm having is it possible that building a dock on the easement somehow conflicts with the terms of the easement?
First, I think Alex had a comment as to that as well. I just want to make sure he wasn't.
Sure.
Oh, yeah, I just wanted to clarify and answer the question. These type of easements are typically used to carry stormwater from the street, in this case after the creek, for the purpose specifically to have a pipe, some kind of drain, to get water off the roads into the creeks.
and
Doesn't sound like such a good idea.
It's not, probably not how we do stormwater retention today. But at the time of this subdivision, that was the idea.
And if I may weigh in, when these easements are meant to preclude structures or the erection of any improvements, they will specifically say that.
Mhm.
So that right of the landowner was not divested of him by virtue of this easement.
Do any of the other board members have any questions or comments?
So one comment I wanted to make, which Mr. Voorhees had raised, which is of concern, is that to address this issue of extending the dock. So the terminus is not, is beyond the wetlands boundary, right?
Yeah, that was one of my questions. I think that Jim tried to address that by saying, I think that would put it beyond the property line. Is that correct?
We don't want to go beyond
So it would put it beyond the property line. It would create, further conflict with what's across the way. So again, Jim's testimony that the 60% light penetration will allow the wetlands to flourish, and the elevation of the dock, I think, is what we're weighing to see if that overcomes this. But it sounds like it is not desirable to extend it farther because of the property line.
Okay. Thank you.
Mr. Chairman, I have a question.
Sure.
Hello, Martha Reichert again for the neighbor, 405 Captain's Neck Lane. My question is a little bit of a hybrid for this board and for the applicant. Jim talked about that the surveyor is going to go back out to stake out the outline, I guess, of the new dock. Is that correct? And so I guess my question then is, will this board keep the hearing record open until it has a chance to inspect that?
Yeah, I think we're leaning toward keeping it open for all purposes for right now.
Thank you.
And we have requested information.
Do any other board members have questions or comments? We're going to leave it open for all purposes at any rate. And do any members of the public have any comments or questions about case number 3147, 64 Down East Lane? So I'll motion that we adjourn for all purposes, case number 3147, Andrew Fleiss, 64 Down East Lane. Can I have a second?
Second that.
And all in favor?
Aye.
Aye. Thank you. Moving on to case number 3149, Claire and David Kershey, 37.
Mr. Chairman, in the interest of municipal efficiency, I would like to bid you all good evening.
You need to come back.
Oh, I'm sorry. Yes, I'll be here.
You'll come back?
Yes, we talked about that. I will definitely be present. I'm going to charge up my computer.
Okay.
Thanks,
See you
Dave.
later.
Good evening, members of the board. My name is Louis Puccio. I'm here representing Schiffered Engineering as well as my client, David Kershey. To start, I'd like to go over some changes to the plan that we've set forth here.
Excuse me, did you produce any documents for us to see in our,
I believe we filed a digital copy.
we don't have any, does anyone on this board have any documents from you about
So we have a
this?
Tuesday at noon deadline, but no board member received any new submissions from you.
Okay.
This is, October 26th.
And
Yeah.
Right.
I
So
had
what-
requested the existing,
What's today?
we had asked for some documents.
I have a presentation that, basically.
No, we need to have the documents so we can look at them before you give a presentation, so that we can, in a sense, have done our homework, sir.
Is the only change in your document that you moved the garage from 10 feet to 15 feet?
No, so we did move it from 10 to 15 feet, and then we also moved it back to alleviate it from the side yard requirement. And then as a result of moving it to 15 feet, we also eliminated the pyramid law variance that we were asking for.
Okay, so right now it's, the garage is 15 feet. We do need documents by Tuesday so we can all review them, but it sounds like minor changes, so just go ahead.
Okay. So I guess first, if I could share my screen here, let me see. Give me a second here. Okay. Right, so the first point, as we just discussed, we can see that the garage here is now 15 feet from this southern property line. And as well, we moved the garage towards the southwest of the property to relieve it of the side yard variance. And then we can see here that the garage is no longer within the pyramid plane, and it's been alleviated of the need for that variance. So this has reduced our variance from it's gone from a 70% deviation to a 50% deviation.
What exactly, since we don't have the documents, what variance are you asking for, sir?
So we were asking for a side yard accessory variance from 30 feet to 15 feet. We were asking for a front yard accessory variance for this porch of 17 feet. And then we were also asking for a variance of the max height of this garage. So basically those are all the variances we're looking at. And I'd also like to go over the tables, because I know in our last meeting on October 11th that there were some questions in regards to them. So I'd like to start with the lot coverage table. So we can see here we have a two-story dwelling that's existing at 2,338 square feet, and that's marked on the site plan accordingly. Here we have a tennis court of 5,105 square feet, also marked on the site plan accordingly. We have a swimming pool of 812 square feet, and then we also, and then those are all the existing structures on the lot. And then we can see that here on the survey that we have an existing dwelling, a tennis court, and the pool. Now, to go into what is proposed, we have the two-story dwelling. We also have a second-story balcony addition in the rear, which is spec'd out here at 769 square feet. It's also shown in the table accordingly. We have a front porch of 147 square feet, which is also reflected on our table. And we have a detached garage of 722 square feet, which is reflected on our table. Our totals for the existing are 8,255, which is 13.76% coverage. In our proposed, we have 9,893, which just about maxes out the lot for the coverage, but it is within the allowable. The next point I'd like to go through are the gross floor area tables, which I know we had some questions on. So if we take a look here, this is the existing first floor plan, and we've gone ahead and we've added some hatches here. So this little crosshatch represents the existing first floor area, excluding the stairwell opening, and it comes out to 1,688 square feet. And then we have here an existing two-car garage of 593 square feet, and this is reflected on our gross floor area table here, 1,688 right there. Now the second floor, which is not having much work done at all to it, other than minor renovations, is 2,197, and this is going to be the existing and the proposed number, as there is no changes to the second floor footprint. And that's also reflected here on this table, 2,197. Now, after we go in and convert the garage to dwelling space, we can see here that our total is 2281, and that is reflected on our table here. And our totals for the existing are 3,885, and the proposed is 4,478, and we are well within the allowable gross floor area. As a part of our building permit application, we do have a letter from the HOA with no objections to this this permit application. Just to touch on the front porch, many houses in this neighborhood do have a front porch, and it is beneficial to the homeowner for when it's raining or snowing. It protects the front door and the sill of the front door and the wood flooring and and whatnot. We've also removed the windows from the garage on the wall that is adjacent to the neighboring property, as this is reflected in the elevations here.
Do you have an elevation that shows the entire house plus the garage?
Yes.
Is the garage how many feet from the house? 5?
Well, now that we've moved it back, it's probably about 10 to 15 feet. I don't know for sure. It's fairly close going, in that direction, but as far as, front and back, it's pretty far set back from the house. And it's even with this line of the proposed balcony, which would remove it from the required side yard.
Thank you.
You're showing a pretty small footprint for your tennis court. Smaller than usual.
Okay.
Do you want to speak to that?
It's been surveyed by a licensed surveyor. Let me see if he has an area spec'd out on here.
I said that because you are getting very close to your max lot coverage.
Right.
And I think of a tennis court as 10,000 square feet with minimum requirements of like 7,200 square feet.
Mm-hmm.
So it's surprising to me to see
this is
5,200 square feet.
So this is spec'd out at 47 by 110.
Mm-hmm.
And if that were to be a rectangle, it would be around 5,000.
Mm-hmm.
But it's not. It's chamfered at the corners.
Yeah.
So I think 5102 is pretty accurate.
That's existing.
Yes.
Got it. Have you guys given any thought to moving the garage further west to center it on the swimming pool and sort of, I guess, accentuate that axis there? And you could come a little bit closer to the pool and maybe even add a pergola, and then it becomes accessory to the pool and eliminates a few more feet on your side yard variance request?
Yes, as a matter, we have given that some thought.
And then what?
It doesn't seem so desirable for the client, but
I guess my point really is that when we're looking at a lot like this that isn't necessarily encumbered by being on the corner and having 2 front yards or having waterfront requirements, you do have a large accessory structural envelope to work with here.
Mm-hmm. Right. I think what happens when you move it too far back and you start moving it a little bit closer to the pool, the access to the actual garage becomes a problem, because then the driveway has to loop around the house, and then...
Well, it's already looping around the house, right?
Right, but if we were to move it further from that southern property line, it would emphasize that even more, and then the garage front facade would almost be behind the actual house, which would create somewhat of an undesirable architectural look.
Well, garages behind houses are more desirable. We don't want to see garage doors from the street.
Right.
So let me put it in this context, because I'll give it a framework that we need to use. You know, one of the criterion that we apply, which Luke is referring to, is whether the benefit that the applicant is seeking could be achieved by some method feasible for the applicant to pursue other than an area variance. And it's entirely possible that the benefit the applicant seeks could be achieved by some method feasible for the applicant to pursue other than an area variance. It seems like the benefit that you're seeking is more interior GFA. And you really haven't been that persuasive that there isn't some other way for you to create more interior GFA other than converting the garage to living space and putting the garage 15 feet from the property line. The other overall criterion that we need to use is there something about this property that distinguishes it, that makes it unique relative to other properties? Here you have a rectangular property in a subdivision with numerous other properties similar in size and configuration to this property. So why would a variance be required here when you have plenty of options? And how would we then be able to respond to another neighbor in the area who says, I also want a garage 15 feet from my property line? You gave it to so-and-so, and then we really don't have a zoning law anymore because we've surrendered it, you know, for no very good reason is what I'm seeing here.
Mm-hmm.
So that's my problem here. The request is still substantial. The setback is 30 feet, and you're 50% over that. You're only putting your garage 15 feet away, and it's not that compelling that you don't have an alternate way to accomplish more interior GFA. I mean, I'm not here, and we're not here to collaborate and design a house for you, but you know, knowing your building envelope, which is pretty substantial, and knowing that you're not contending with a difficult property shape, no wetlands, you have other options. You have other options than seeking a variance. So I'm just, providing you my guidance that it's hard to see a way where this board could justify a 15-foot setback on a garage. But I'll open it to everybody.
Yeah, I mean, you could add to the house, get the master suite adjacent to the garage via a good hallway or something like that. Also, we haven't spent a lot of time on the garage height, but Mrs. Riley can tell you a lot about our opinion on accessory garage heights. It's probably not something that would really go anywhere.
Our board's mandate, and we see our purpose as protecting the integrity of the village zoning code. So there has to be some compelling reason for varying from the code. And I'm not seeing a compelling reason. I'd love to be able to accommodate, different architectural plans, but then we have to look at, the proverbial domino effect of that. Why doesn't everybody, have a variance when they want one? There has to be something compelling about the variance request, or something compelling about the obstacles you're confronting with this property size, shape, or something else, and I'm not seeing it, but Julia or Joyce, or does anybody have any other questions or comments?
No, but I would, well, I don't know what, are you, depending on what we're doing with this application, I would like to see the documents, and I'd like the building department to see these documents now, since there's a change.
Do you want to close it?
Sure, no, we can keep it open for all purposes.
I
So
can close
I
it.
just wanted to make a clarifying
Sure.
point, that the front porch is considered part of the primary structure, and follows the primary structure setbacks. I thought I heard it said that it was an accessory setback,
Yeah.
I just wanted to clarify that.
You
Yep.
did hear that, I wondered, so that adds to the GFA?
Well,
No,
it's
it doesn't
unenclosed.
relate to
Doesn't have a
GFA.
top? No, it does, no?
No, it's not GFA, because it's open. It's just the setback that's applicable is the primary structure setback, not the accessory structure setback.
Julia, do you have any questions or comments?
Nothing to add that hasn't already been said.
Okay, do you think we should leave it open for all purposes or close it for decision?
I'm prepared to close it for decision.
I agree, close for
I
decision.
agree, but I'd still like to see the documents before I make a decision personally.
100%.
Is that okay if we close it for decision, or do you want to
It's not have
present
to-
more?
I think if it's okay, I'd like to leave it open to present.
Alternatives?
Yes.
Okay, then I'll motion to leave case number 3149, Claire and David Kershey, 37 Pheasant Close North, open for all purposes, and we'll see you as soon as you're ready. Can I have a second on that?
I'll second that.
And all in favor of leaving it open for all purposes, case number 3149, 37 Pheasant Close North, please say aye.
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 Aye. Okay, thank you.
Thank you.
So I just would note that this would go on for November 15th, but if you're not ready for that, we would just ask for a request for adjournment for the December meeting.
Is that okay, Louis?
Yes.
So we're ready to hear new cases. Case number 3148, Heart of the Hamptons, 44 Meeting House Lane.
May I ask just a point of clarification before we start the next case? Which is, Alex, am I correct in that my understanding is that a digital copy of materials are not part of the record? It is only a paper copy that is considered to be part of the record for these cases?
Yeah, I'm not sure what would constitute part of the record per se. We did tell them that because they had missed the deadline, there was no way to get paper copies to the board. So we suggested that they could come to the meeting and to explain the changes there and present the paper copy that way. But they did provide a digital copy so that we could put it on the Dropbox and share the screen because they intended to present it tonight. Because it was presented tonight at the hearing, I understand that it is part of the public record.
I'm gonna follow up on that outside of the confines of this public meeting, but I'd like to understand that better, because my understanding had been that digital copies do not count as being inclusive of the total record. So for our purposes in advance, reviewing the digital copies only doesn't mean that we're seeing everything, but the paper copies meant that we were seeing everything in advance that was available to us.
Yeah, I think the digital copies reflect everything that's submitted in paper. We ask for everything in both formats.
Okay. Well, so it comes in one format, you still accept it though?
We don't. We ask for it in both formats.
Okay. I'm just wondering if we should have even heard this tonight, if we didn't have the opportunity to see the paper copies, all that is available with digital.
Right, and that's a decision that's up to the board, and we notified the applicant as much.
Mark?
We did hear it.
Yeah, we heard it.
I find it very difficult. I have a laptop, so I like the paper to back it up, especially for like surveys. And I don't like to be caught out where I don't. If I don't have the paper, I think we deserve that. That's what I think.
My understanding had always been that the digital copy was just for, as a courtesy,
As a
but it
courtesy,
wasn't a formal submission, so. We can go on. I just wanted to talk that through.
Linda, do you want to present case number 3148? Is that what you started to do?
If you're ready.
Yes.
Yes.
Mhm.
This is a new case, so I just want to say for the record that I did submit affidavits of posting and mailing. I am here on behalf of Heart of the Hamptons, which is a not-for-profit organization that runs a food pantry. It currently runs the food pantry on the premises of the Catholic Church down on Hill Street. And they have to move out of there and have struck an agreement with the village of Southampton to enter into an agreement to use the former ambulance garage at 44 Meeting House Lane, which is owned by the village. Also, the village board, it is a special permit use, but it's not a special permit application that you will be hearing because the way the law is drafted at this point, the village board had authority and gave itself authority to grant special permit for this use, among others. So the village board granted the special permit for the use on March 29th, 2022. And thereafter, we submitted a site plan to the planning board, and they granted site plan approval subject to conditions, which have been submitted as part of the packet on August 15th, 2002. We also went to the Board of Historic Preservation and Architectural Review, as we're required to do. And they had some strong objections, so strong that they said they would not grant it, to a couple of features, one being the dormer, the proposed dormer on the second floor of the existing building, which had been proposed to be put on the east side of the second floor, where it was, frankly, in a conforming location. The Board of Historic Preservation and Architectural Review found it disharmonious and said that, there is a residential, it was important to note, there is a residential neighbor next door on the east in fairly close proximity. And she objected to the dormer, as did some of the other neighbors. Her objections were based on the fact that there might be lights shining into her second floor and that her second floor bedroom windows might be visible from the offices that were proposed on the second floor. So the Architectural Review Board had some other concerns which we have addressed with them separately. They had nothing to do with variance relief. So although we can show you how we're changing the site plan, those other elements have no bearing on our application or what we're seeking tonight. So the last time we went before the Board of Historic Preservation and Architectural Review was Monday of this week, October 24th. And they made it clear at the meeting that they are prepared to approve the plan submitted to them at this point on the condition that the Zoning Board of Appeals grants the variance. And they didn't want to go ahead and, finally adopt anything until you had heard the application. So we're here tonight to a great extent because The village wants us, and when I say us, I mean the Heart of the Hamptons, to make the proposed improvements to the second floor. They've got problems with the condition of that building, and they are looking to improve it, and they want the expansion themselves, and by the village, I mean the Village Board of Trustees. It is being paid for by the Heart of the Hamptons, all of the renovation that is being done. And also it was precipitated, frankly, by the comments that the Board of Architectural Review and Historic Preservation had. So jumping to the application itself, which is simply to move, it seeks variance relief, dimensional relief, to move the proposed dormer from what had been, it's not before you, but what had been the east side, to move it to the west side of the building. The lot size is 14,231 square feet. It's located in the 12.5 or 12.5 district. It's in a residential district right at the edge of that district. The west side of the property adjoins the Presbyterian Church parking lot, which is leased to the village for public use, the parking lot. The church has specifically consented to the use of the parking lot by clients of Heart of the Hamptons, but we need a westerly, side yard setback, and pyramid relief. The existing building is set back 6.4 feet from the property line. We are going to set the dormer in, so it'll be a little bit further. It'll be 6.4 feet from the property line, but the required setback is 15 feet. So obviously, it still requires some degree of variance relief from the side yard setback because it is within the 15-foot setback, although less so than the existing first floor. Pyramid relief is required under 116-12E2, and you have the pyramid document in your plans. There is a plan shown with one of the sheets, and it involves an encroachment from the existing building. The existing building, by the way, does intrude into the sky plane itself. The encroachment in the existing building is 1,447 cubic feet. The proposed dormer will add another 3,341 cubic feet into the sky plane, so that the total encroachment will be 4,788 cubic feet. Excuse me if I said square feet before, I meant cubic feet. The requested relief meets the requirements of your code under 116-28C1A, which is the so-called 50% rule, whereby enlargement or extension is not to exceed in all 50% of the usable floor area of the building. Sheet A101 gives you the calculation of the existing first floor usable space at 2,325 square feet. Sheet A103 provides the calculation of the existing second floor usable square footage, which is 1,100 I must have a typo here. It's like 1,226 square feet. And the proposed addition of the usable floor area to the second floor, which is where the only expansion is 830 square feet. So we're adding 830 square feet of floor area to the second floor, and that is, if the total existing usable area is 3,551 square feet, half of that would be 177.5 square feet, and we're proposing 830. So it meets that criteria. Addressing the criteria under village law, state village law 7712B, as well as under your code and pursuant to Sasso v. Osgood, et cetera, we contend that no undesirable change will be created that would be a detriment to any nearby properties. The installation on the dormer on the east side was urged on us by the Board of Architectural Review and Historic Preservation to get it away from the residential side of the street.
On the west side.
On the west side, to get it away from there, to put it on the west so that it would overlook a parking lot, a very large parking lot. The church itself is approximately 300 feet or so from where this dormer is going to be. And there's nobody else who will be seen out of there looking into there. It won't shed light on any residential properties. And across the street and next door on that side basically is devoted to community service uses. The museum is across the street and the church is next door. There is an office building across the street, directly across the street from the ambulance garage. It's of a similar sort of size and dimension as the ambulance garage is. And these dormers will not look out on that at all. In fact, the Board of Architectural Review and Historic Preservation said that they thought that even though the dormer in some ways will be more visible to the public, because coming down that street you will see it from the road, they thought the additional fenestration and the dormer shape and whatever would be actually just as well to look at as the roof. So the applicant's goal here is to run a facility like it does now. It has to move. It has to get out of where it is. That has sufficient room for a handful of offices and a storage facility for the food that it will be regularly dispensing to local residents. It plans to run pretty much the same program it does now at the Catholic Church, and that requires storage space. And the first floor is pretty much devoted to storage shelves and units for storing food. The offices there'll be 3 offices on the second floor, which could not be fit up there, given the slope that it's a ridged roof without the dormer. There is a large stairwell there now. The stairway is existing, and it takes up quite a bit of the second floor area in the center where you've got headroom. The enlargement of the space is critical to the heart of the Hamptons, and they have made, this is not a case where they did not make any effort to achieve their goal without seeking variance relief. They tried hard to achieve their goal without seeking variance relief and found that there is no other reasonably feasible alternative location because it was not going to be approved by the Board of Historic Preservation and Architectural Review. The applicant did look at other options. Another option, you might say, would be to build out the back, of the first floor. But that is, for one thing, hugely more expensive because it involves foundations and stuff like that. And it would intrude on the next door neighbor who had a lot of objection to the dormer. This, because her property, it would still be very, very close to extending the building in the back. So they felt like they explored all other options and felt that they really had no other alternative but to come here and apply for this relief. It's not, we're arguing that it is not substantial. The existing roof ridge is 32 feet, which in fact is 2 feet, pre-existing is 2 feet over what the limit is in the R12-5 district for properties that have less than 20,000 square feet of area. But we tucked the dormer underneath that. The dormer is no more than 30 feet in height. It's below the ridge of the roof and projects downward. So it's tucked in lower than the height and doesn't extend as far as the width. So it's not increasing the height. It's less than the existing height, and it's less than the existing width. And I would argue that substantiality isn't an issue that can be reduced purely to numbers and percentages, and it's a criteria that can't be looked at without performing the entire balancing act, which is balancing the benefit to the applicant against the effect that granting this particular variance is going to have on the neighborhood. Here, next to and across the street from community service uses, and an enormously large parking lot, we contend that it's not going to have any any deleterious effect on the neighborhood. There are no special environmental features here. It is not a self-created hardship. This is a community organization that's valued by the village enough that the village has offered to lease essentially the property to them, assuming they make certain improvements, which will be an investment for them and the community. Because at the end of the day, that building is going to belong to the village. It's a municipal building, always was. It's, that's what it is. The Village Board of Trustees and the Planning Board both adopted resolutions that included finding it a Type 2 action pursuant to SECRA, so there's no further discussion to be had there. I will tell you that because the Planning Board approval, which was an approval on the site plan, had the dormer on the other side, we are going to have to go back to them to get a modification of their conditions. And so and we have, in fact, prepared plans that we hope will be approved by you that would address some of the other concerns that aren't relevant to the variance, like the location of the dumpster and the location of the walk-in freezer in the back. Those things we are also changing, but they don't have to do with you, and we're happy to submit those plans. We've done them already, but we wanted to keep the ball rolling, and really the important thing that we're asking for from you is the pyramid and the setback relief. So having said that, the architect is here, so he can answer any questions you have about the design and the architecture. Do you want to, I don't know if.
Do we have questions?
Do you
I'm
have?
not sure if we have questions.
Okay.
I just, the benefit that you're achieving is you're able to add offices on the second floor.
Yes, yeah,
That's the benefit.
yeah.
Okay.
That's the benefit, having.
Where are the offices now?
There are no offices there now. It's an ambulance garage. It's been, yeah.
What is the organization, where are the offices that your client uses now?
They use the Catholic Church. They have space at the Catholic Church, the main Catholic Church on Hill Street.
I've been there, I've donated stuff, but
yeah.
they have offices there?
Yes, yes,
Okay.
yes. Yeah, I mean, they're not open to the public the way, you know, their main area is, but they do. And I have Molly Bishop here, who is the executive director of Heart of the Hamptons, and she could answer any of those kinds of questions for you and speak to the need. If
Yeah, well, let's see what questions the board has. I mean, we have a
Okay.
limited purview, you know, here, meaning
Yeah.
that we're looking at variance relief, a side yard setback, and pyramid law relief for second floor dormers overlooking a parking lot. So we're focused on our criterion for granting variances, and let's see what questions any board members might have with respect to our 5-point test.
So I have a question for Alex, actually. The variance request number 2, decrease the minimum required setback from a side lot line. So the dormer doesn't go over the existing footprint. Why do they need that variance?
So any new construction has to conform with the current setbacks, regardless of where the existing building is. So even though they're not expanding the footprint of this building, because the dormer is past the setback line, it's what triggers a variance. Does that make sense?
I mean, I understand where you're coming from. It doesn't make sense to me, but
It's similar to other cases the board has seen, for example, with building height. For example, if a building is non-conforming and it's too tall for the zoning district, it doesn't mean you build up to the height of the roof of that building. You still have to conform with the height regulations. So that means anything that's higher than height regulations, whether or not it's up to the top of the existing building, we still need a variance.
thank you, Alex.
Yeah, no problem.
But your point is well taken in that in no way are they expanding the nonconformity. They're not making this any closer to the side yard than the building already is. In fact, it's not as far, it's not as close to the side yard as the existing building. So, I mean, I see your point. I think that's part of our balanced test.
Chair.
Chair. Sure. Good evening. Ben Chaliff and Rogers Architects. Sorry, Alex, didn't mean to cut you off.
Oh, no, I'm sorry. I just wanted to make a clarifying point, and I don't know if maybe I misheard or misunderstood what Linda said, but I believe on Monday the Architecture Review Board did pass a resolution approving the architectural plans subject to certain conditions. I just wanted to clarify that. It's my recollection.
So what does that, you mean, it was accepted?
Well, I think the architecture plans were accepted subject to certain conditions. One of the conditions was that you would have to get a variance from this board.
I see.
I just wanted to state something simply. I'm sorry. Ben Chaliff and Rogers Architects for the applicant. I believe Ms. Riley misstated the existing height of the ridge. It's 26 foot 4 inches, and we're staying below that. I think she said something even higher. So I just wanted to say it's lower than it was stated. So I'm here if you have more questions.
What would be allowed? 32, 35?
30.
30.
30?
30. Okay, I read the plans wrong.
Do you have any questions?
Yeah, I have one question. In terms of this proposed plan, is there additional screening that's going in on the east side of this lot? And is that what I'm seeing here?
Yes, we're going to put in extra screening, yeah. Yes.
Just on the east side, or?
On the east side, yes. Not on the parking lot side.
Yeah.
Because there's a sidewalk that runs there, and there's a side door, which is actually where the volunteers are going to be distributing the food out of. So there isn't, it doesn't work. And the planning board agreed to have screening between the parking lot of the church parking lot and the building.
Okay.
It just doesn't, there's no room for it.
Okay. Thank you.
We have lots of landscaping proposed, which is all part of the planning board site plan, yeah.
Well, you do have some landscaping on the southern portion, not between the dormer and the parking lot, but you do have landscaping that,
On the east side.
is that your landscaping? No, it looks like it's on the west side, but it could be, it's on your C100 drawing, but
I can clarify that. We were proposing, and I tried to submit an updated set to you, but I was too late for this week. So the rendering that you're looking at and the site plan that you're looking at, the proposed dumpster enclosure that is shown prominently there in the front is gone. They're not doing that anymore. And there were some taller proposed evergreens on either side of a doorway on the west side of the building. We flipped, we removed that, and there's some low plantings proposed there, but we returned the existing west-facing door at the north end of the west elevation to its existing location, and the existing window opening there would also remain a window. So that tall planting is removed. But as you can see, it's an incredibly narrow strip of land there, so we're keeping things on the lower side.
Well, it all seems substantially lower than the building directly across the street, right? Which is 2 full stories of brick, federal details.
Right. It's also significantly lower than the residence to the east, which is maxed out, I believe, right at the maximum height. Has a flat roof to accommodate its height restriction, I believe.
Can see that.
Julia, do you have any questions or comments at this point?
No, I don't, Mark.
Susan?
No.
Okay, do any members of the public wish to be heard on this application?
Good evening, Mr. Chairman, members of the board. My name is Anton Borovina, and I represent Joanne Hale across the street, as well as Jim McFarland and others. We oppose the granting of the variances for a pyramid and side yard restrictions that are imposed by the code. As the board is aware, the board is required to make certain determinations as to whether or not a variance is needed. And one of them happens to be, I'll discuss others, one of them happens to be whether or not the strict compliance with the code as it currently exists would pose a practical difficulty or unnecessary hardship. And I submitted does not, and by the way, this was actually essentially acknowledged by Heart of the Hamptons itself. In minutes of the planning board meeting held on March 14, 2022, and I will give this to the board, the full minutes, which is a matter of public record. The applicant represented no variances will be needed. It will be similar to the church use that has existed. It will act in the same manner it has at the church. There will be more square footage and a walk-in elevator, a refrigerator. The historical nature of the use will be preserved.
What was the date on that?
March 14, 2022.
So preceding the Architectural Review Board.
Yes, sir.
Changing their plans.
Well, no, this is I'm reading the minutes of the planning board.
Right, where they said they wouldn't need variances, and they don't need variances, or wouldn't need variances, had the Architectural Review Board not.
I'm going to get, well.
Do we agree?
Well, in the context of that would be correct, yes,
Okay.
yes. Now.
So it's not really fair to say that they promised they would never need variances, and they are now going back on their word, which is what you're suggesting.
Well, what I'm stating, by the way, not a suggestion, is that the square foot, that their existing use at the church and let me get into that immediately. The existing use of the church is at a basement. The basement already accommodates, and they have been successfully operating a food pantry operation from the basement for many years. It already accommodates office use, a food pantry area, a place for the dispensing of clothing, an indoor refrigeration unit, and bathroom. Now, and the question then becomes, in as much as it had existing office space, and they're now moving into a first floor area, the first floor area alone, and you can inspect the premises yourself, and make your own comparison, of course. The square footage of the first floor, without having to do anything on the second floor, is larger than what exists in the basement. So the essential functions of the Heart of the Hamptons, in terms of provision of food pantry, clothing, having office space, and bathroom, and that can already fit within the four corners of the first floor as it currently exists, without the need of a variance on the second floor.
But you're assuming that their size in their current location is adequate for them.
Well,
we don't know that. We
well,
can't say.
I can, if I may, in the in the letter to the applicant's letter to the Board of Trustees on February 22nd, 2022, the Heart of the Hamptons represented, and I'll quote it: "The food pantry currently operates inside a nearby church in an area with less square footage than the proposed facility. The proposed site will be larger and will enable them to have a larger storage area and a walk-in refrigerator, which will better enable them to serve their clients. So the space is more than adequate." That's what they said. That's at page 6, by the way, of their application. At page 4, they say, "The Heart of the Hamptons food pantry currently operates in a facility only a few blocks away. Its operations are not expected to change with the move to a different building in the vicinity of the existing site." So this is what they're saying. These are the representations that they made to the Board of Trustees and to the Planning Board, and including to the ARB. The point is that there is no compelling reason, therefore, to grant the variance. And I do submit that it will be out of character if the variance is granted. That is, there are no dormers. There are homes located on the east side. There are homes, by the way, on the west side. It does face a parking lot, and also there are homes on the south side. None of those homes have this kind of a dormer within its structure. And by the way, they all conform, by the way, to the pyramid, to the sky plane prescribed by the village code already. I also contend that the variance is substantial. The Heart of the Hamptons wants to pierce the sky plane by an additional 3,341 cubic feet on top of the 1,447 cubic feet that currently exist. That is a substantial punch through the sky plane. It's not a minor one. They also want to have a setback on the west side, relief from the side yard restrictions on the west side, from 15 feet to 6.4 feet, which is greater than a 50% reduction in the associated side yard. These are substantial requests for variance relief, and it's not necessary in as much as the building already, as it currently exists, without having to do a darn thing on the second floor, is capable of satisfying the needs of the Heart of the Hamptons more than adequately. And they've said this. I'm not saying this. This is what they said. And that's why I respectively request that the application for variance relief be denied. I'm done.
Well, let's see if any other members of the public wish to be heard.
I just wanted to respond.
No, you will have that opportunity. I mean, I would say just that the test that we're applying is not, and Jeffrey, I'll defer to you if I'm saying something other than what's accurate, but we're following a test which is balancing the benefits to be realized by the applicant against the potential detriment to the health, safety, and general welfare of the neighborhood or community if the variance were to be granted. We have a balancing test, and we have 5 criteria that we follow. That's our basis. It's not a practical difficulty or hardship.
I did want to clarify that. I think that what council was citing would actually apply to a use variance request. These are area variance requests. So the board would rely upon the criteria that the chairman just mentioned. So essentially there is the balancing of what benefit is gained to the applicant as opposed to any detriment, and then takes into the other 5 criteria that are beneath that, but it's not the use variance thing.
Okay.
Hi, Mr. Chairman, members of the board. I'm Molly Bishop, the Executive Director of Heart of the Hamptons. I'd just like to clarify that the comments that were made to the Board of Trustees was based on having the second floor usable space, because that is part of our licensing agreement with the village, that the space would be turned into a 2-story year-round what do I want to say, heated, weather-safe building with that amount of usable space. The square footage would be, with the dormer, would still be smaller than what we have now, but we hope that we would be more efficient in this new space since we will not be in a basement anymore. We don't have indoor refrigeration in our current space, so we just have wall refrigerators. Also, our client base has grown quite a bit in the last 2 years, and we can't stay where we are even if it still worked for us. Our lease is up in a year, and so for 3 years we have known that we needed to find a new home. It's taken us 2 years. Our license agreement was signed in December of 2020, so we're coming up on 2 years of our lease already with the village that we've been working through these approval processes. But we know we only have 1 year left at Sacred Heart anyway, so we're under the gun to make the accommodations and be able to move into them. So thank you for your time. I'm here too if you have any other questions about our operation or our use of the space.
My name's Judy Maysels, and I just want to make one point, because I've been going to a lot of these meetings with this Heart of the Hamptons, and they've asked for one thing, and they've managed to get that by hard work with all the boards and everything. And now, all of a sudden, that's not enough. They now have to change it when it's already been... do you understand what I mean? It's like, this was what we want, help us get it, and, and all of a sudden, now they know they're close to getting it, then boom, we want another big space, and it just doesn't seem quite fair.
I understand what you're saying, but they wouldn't be here before us had the Architectural Review Board not changed their plans on them.
No, but maybe they should have been asking for it all along.
They had asked for it in a compliant location.
I think what happened was, and although I'm not sure it's being appreciated here, they had a location that was within the zoning code, and I think the ARB chose to accommodate a neighbor, even though arguably they could have not done that, okay? It was a bit of a stretch of their authority to say that a dormer could not be installed on the east side. It was within the zoning code. The only reason why we're here is because we're accommodating essentially that neighbor and the ARB's desire to cause this applicant to be perhaps a better neighbor and put a dormer that overlooks a parking lot. I mean, I for one, I'm not seeing a strong, substantial detriment to the neighborhood by having a dormer overlook a parking lot. And that's our standard. Our standard is to balance the benefit to the applicant, which seems clear to us, which is to have offices on a second floor. Did they have another feasible location? Yes, they did. within the zoning code, they could have installed this dormer on the east side. Instead, they're coming here because they were told by one board that they couldn't. So I'm just doing a balancing test. How much of a detriment really is it to the neighborhood to have a dormer overlooking a parking lot within the building's existing setback? I'm not seeing a substantial detriment.
Yeah,
But
and they pursued that avenue as well. And Mark speaks directly to the fact that the hardship is not self-created. They had pursued the more code-compliant avenue and were asked by another regulating board to move it.
Go ahead.
Jim McFarland, for the opposition. The ARB and the Heart of the Hamptons did a Pearl Harbor on us. We didn't know that they were going to reappear in this last meeting. At the meeting prior to that, the ARB had a number of items that they said flat blank, we will not approve this. And one of them was the dormer. And the idea of not having any dormer at all actually came from the ARB. Why do we want to change the character of that building? It has a certain historical significance, was built by volunteers, by volunteer money, and do we have to have this big ugly dormer on it? So I've been cogitating that. I just happen to be an industrial engineer, and industrial engineers look for the cheapest, fastest, easiest, best way to produce things. And no industrial engineer has been called on site to rearrange the interior of this building prior to deciding that upstairs lots of space is needed. I did a quick analysis, and I could give it to you. I think you've made up your minds, though, already. I don't know if I should waste my time.
We're going to count on the professional architect to lay out the spaces.
An architect designs, an industrial engineer figures out the best way and easiest and cheapest way to do things. And if you think that we have a point, my crew, my people, will pay for an industrial engineer to analyze the requirements of the Heart of the Hamptons and devise an interior flow and space and organization and maintenance that will enable them to do that within that building. And if this company, this certified, verifiable company can't figure this out, then the best way to do is not to change the exterior of the building, but to tack on something that looks just like the building on the rear, that's got a basement in it for the mechanicals, that's got an office in it. I don't know, have you looked at the plans, what they have there? They've got lots of space that could be utilized in a dual purpose way. For example, a meeting room. I don't know if that's part of a pantry type operation. Do people have to meet before they get their food? I don't know. But if you have to have a meeting room, you can have all your storage things in wheeled racks and stacks, push them to the side, and have your meeting room. Do they have meetings every day at Heart of the Hamptons? I don't know. Let's not forget, this is a private charity. It's doing social services, and it sits on the end of a long chain of social services, federal, state, county, and town. And if you just looked at the town social services alone, they have a catalog of services that they provide. So that the Heart of the Hamptons has to be here and has to have this little dormer is kind of squeezing the last bit of drop of blood out of the turnip, in my opinion. They're getting a bigger space to start with, and I'll bet you that an engineering company can figure out a way to give them everything they want without having to put dormers on the roof and have a zoning board of appeals permission. That's about it.
Are there any other members of the public who wish to be heard? Julia or, oh, sorry.
Yeah, Mark Epley.
would challenge, my question would be, how many people have actually gone to Heart of the Hamptons to watch the operations at the church? If you realize they use almost that entire basement at the church, which is a much larger space than the ambulance barn. And without the dormer on the second floor, that second floor is completely useless. The Heart of the Hamptons helps so many people in this community, you have no idea. Your neighbors, they help pay electric bills, they help families who've lost loved ones, they help during food drives, I mean, this is a great organization. It's been around here for decades. And unfortunately, because of policy, the Catholic Church and the diocese was making all the Catholic churches move any non-Catholic related entity out of their spaces. That's what they've been doing over the last 10 years. My business has been impacted by this. I've had to make moves, and this is another one. So the option to stay in the church, which is a much larger space, is not there. This is the best spot for it. I thank you guys for keeping your focus on what what you have to do. The only reason why Heart of the Hamptons is here is because of the request from the neighbors who've opposed this project from the beginning. And they've made every single accommodation they can, put them back in front of the ZBA where they didn't have to be at. So I thank you guys for hearing them. Thanks.
Thank you. Do you have any other questions? Okay, so I'm going to motion to close for all purposes, case number 3148, Heart of the Hamptons. Do I have a second?
Second.
Second.
And all in favor?
Aye.
Aye.
So then we'll motion to close the public hearing of the Zoning Board of Appeals, Thursday, October 27th, 2022. Can I have a second?
Second that.
Second.
Okay, all in favor?
Aye.
Okay. We're closed.